The judge says to the defense attorney, "Counselor, call your next witness." The defense attorney says, "Your Honor, at this time we call Dr. Jones to testify." I jump up immediately. I say, "Objection, Judge. This medical expert isn't qualified to testify." What happens next? You want to know the answer? Come join me for a moment as I share with you exactly what happens. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. So now this is a medical malpractice trial. The plaintiff, we have finished putting on all of our testimony and all of our witnesses and all of our evidence. The defense now has their chance to put on their witnesses. So now as the first witness, the defense attorney decides he's going to call an orthopedic surgeon to come in and testify as their medical expert. But now, the person that we have sued, that my client has sued, is a neurosurgeon. We are claiming in this case that this neurosurgeon performed surgery improperly on my client's back injury. So now the judge turns to me and says, "Mr. Oginski, what's the problem?" I said, "Judge, this expert that he wants to put on and testify is not of the same specialty as our medical expert. We don't feel he's qualified to testify as an expert on the issues in this case." So now the judge turns to the defense attorney and say, "What do you have to say about that, counselor?" And now the defense attorney will begin arguing to the judge why, from a legal standpoint, this orthopedic surgeon should be allowed to testify and that they need not be the exact same specialties. In all likelihood, the judge will want to know what this doctor's qualifications are. So now for the next few minutes, the defense attorney will ask his own doctor, his medical expert, about his credentials. "Doctor, where did you go to medical school? Where did you do your residency training? How about your fellowship training? How many years are you in practice? Are you licensed? Are you board certified? Have you performed this type of surgery, this back surgery that was done in this case?" Now, if the doctor says, "Yes, I have. I performed many of these surgeries. I do this all the time," what do you think the judge is going to say? He's going to say, "I'm going to allow this doctor to testify." And it'll be up to the jury to determine whether or not they believe this doctor is credible. You should know that there are some instances where a doctor is brought in having nothing to do whatsoever with the specialty that we are claiming. In that instance, let's say he brought in a chiropractor to talk about the standard of care for a neurosurgeon. In all likelihood, the chiropractor who has never done neurosurgery would not be able to testify about what the standard of care was for a board-certified neurosurgeon here in New York. In that instance, the judge would say, "No, I'm not allowing him to testify." But where you have two specialties, where they do the same type of surgery, in all likelihood, the judge is going to allow that expert to testify. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.